Hello, everyone, and welcome to our virtual series on local government law. This training series is intended to provide a concise overview of the legal aspects of being a local elected or appointed official. The sessions are based on chapters from the book, Local Government Law, a practical guidebook for public officials on city councils, community boards, and planning commissions, and it's authored by our presenter, Jerry Fisher. Jerry is a well-known and respected land use attorney with decades of experience working throughout Southeast Michigan. Before we get started, I have just a few reminders. The session's being recorded, and the recording will be made available on our website, as all of the other recordings as well. If you have any questions, please use the chat option in Zoom and direct your questions to Jim Schaefer. Jim will moderate a question and answer period after the presentation. So let's get started. Please join me in welcoming Jerry Fisher.
Well, welcome everybody, and 1,000 hellos to everybody that has tuned in today, and the same for anybody that may download this in the future. Happy to have you here, and hope that I can impart some insight for you. We've got a two-part program. First part is maybe some technical law on eminent domain, also known as condemnation. And then the related subject of regulatory takings. And then the second part of this will be on meet the court system, local government, and meet the local government attorney. And this is more of a practical information for people that aren't as familiar with the court system or don't know how unbelievably talented local government attorneys are. So let's get started. And this is, as Ryan indicated, and I appreciate Ryan didn't say that this was a book written by an old man. And this is a local government law, a book that was published in May 2021. And I'm grateful that we've had the opportunity to start this program to go through the various chapters. Albeit that we can't go through in significant detail, but enough to provide some overall insight, hopefully. So let's get started. Eminent domain and regulatory takings. The first subject here is taking, quote unquote, private property by the government. And eminent domain, also known as condemnation in many instances, results in the government actually obtaining total or partial ownership of property, such as the right to possess the property for some purpose, like build a building, the right for an easement to run a sewer line or a water line across the property, or things of that, to grade the property and all of those kinds of things. And taking property, taking ownership of an interest is the objective of eminent domain. And just pause for a moment so we can compare this with regulatory taking, which does not involve the government attempting to own property. Rather, with regulatory taking, the government seeks to regulate, such as by zoning or something of that nature. And as a result of applying the regulation, the property owner claims that it results in what is essentially the equivalent of eminent domain. In other words, it's the equivalent of the government taking ownership. And so the eminent domain involves the involuntary transfer of title. And that's an important thing because one of the most significant characteristics is that the government isn't actually entitled to the property when it goes after it, assuming it's authorized. There are some instances where the government is not necessarily authorized to take particular property, and we'll talk a little bit about some of those instances in a moment. But the government is generally entitled to end up owning that property. The question then for the property owner is, how much money do I get for this property? And that's something we'll also talk about in a moment. So, this involuntary extraction of property from the owner, you have to ask yourself, well, does this rule make sense? Since we have all these the Bill of Rights and all these freedoms and all that sort of thing. So does it make sense? And the answer is that it makes all the practical sense in the world. The best example is where a road is needed. An important road is needed from point A to point B, and you've got 100 property owners. Obviously, it would be an almost certainty that as the government approaches various property owners, they're going to say, no, I'm not interested in selling my property. And so it would basically prohibit the government from building the road. And another example in the days gone by where the government needed a lighthouse in a certain place adjacent to a coast that created problems. And if the government couldn't take the property for that purpose, the lighthouse couldn't be constructed and save lives. So the historic basis for takings as a constitutional matter is the Bill of Rights, the Fifth Amendment. And one of the phrases in that Fifth Amendment is, nor shall private property be taken for public use without just compensation. So we start with the premise that it's going to be private property, and that leads to two other requirements. One, that property can only be taken for public use, and that when the government does exercise its power of eminent domain, it must pay just compensation. Now, it's as an aside, but it's an important and interesting aside, that until 1922, this Fifth Amendment taking rule applied only to cases in which the government was intentionally taking private property. In other words, exercising eminent domain. And that the Fifth Amendment did not apply, Fifth Amendment takings clause did not apply to cases in which the government regulation was so burdensome that it was effectively a taking. So there were cases that were attempted in earlier days, and the court always rejected them. And so clearly, the original intent of the Constitution was not to create a regulatory taking claim for private property owners, but in 1922, the government, the court held that Oliver Wendell Holmes penned the decision that where regulation, quote unquote, goes too far, then the result is that one or more people would be forced to bear public burdens, which in all fairness and justice should be borne by the public as a whole. And therefore, it'll be considered to be a taking. And that was a very extreme case. And if there was going to be a case that would come along, that was it. And I won't go into all the relatively boring details of the case, but trust me that it was a justifiable a case for determining that regulatory taking should exist. So again, the framers of the Constitution proposed the rule that private property shall not be taken for public use without just compensation. So that these two variables are here. Public use. What is public use? Why is, what does that mean? And to tell you the truth, that public use requirement has been unnecessarily, I shouldn't say that, has been complicated by the court. And there are two separate sets of rules on that public use situation, because under Michigan law, property can be taken by eminent domain under the Michigan Constitution as well. So where property is taken in federal court under the federal Constitution, public use means that property is being taken from owner A for purposes of the government, like building a road, taking property for a drainage system and things of that nature, but not the intent was not for the government to take from private property owner A and turn around and give it to private owner B. And in that kind of situation, the court would hold generally that that's not a public use. If the property in the hands of private owner B is a private use for B, not a public use for the benefit of the country or the state or the local government. But as I say, the court kind of compromised this whole idea when the rubber was hitting the road in a case that was achieving what was considered to be a legitimate purpose. And one of the examples was in Hawaii, where you had a dozen or half a dozen families that owned all the property in Hawaii before statehood and or after statehood, and people just rented the property from them, and people tried to buy it, and unfortunately the people wouldn't sell, maybe for tax purposes or otherwise, and so the state of Hawaii passed a statute saying that the state would take the property from these families and then turn it over and sell it to the individuals that had been leasing the property. And so that was obviously taking property from A and turning it over to B for private use. And the holding of the court in that and maybe an earlier case was that, in fact, there was an earlier case, Berman versus Parker, that held that where the legislative body, and it can be the Congress or state legislature, passes a rule that authorizes the government to take property from A and give it to B, that will be considered to be a public use. So the test under federal law and whether there's a public use is whether the legislature has authorized it when it's a situation of A taking it for B. Michigan law, in a case a number of years ago, where the city of Detroit was taking property for General Motors for a plant in Hamtramck, the city of Detroit was taking the property and giving it to General Motors for the construction of a plant. Now, in that case, the court held that under all the circumstances, because Detroit was in trouble economically, that this was providing for many jobs and all that sort of thing, that it was a public use. And that holding stayed in effect until later on, when like 2004, 2005 or so, when the Wayne County was expanding the metro airport, and they were taking property, and they had taken more property than they needed, and they were going to then parcel it out to developers to develop this amazing multi-use project, and it was challenged under public use, and the case is Hathcock versus Wayne County, and in that case, the court reversed the earlier case involving the General Motors plant and held that public use only existed under 3 discrete circumstances that the court outlined. Following that decision, the Michigan Constitution was amended and basically codified those 3 purposes and limited to 3 that would amount to public use. And I mean, there were, for example, things where the government was doing away with slum situations that were contrary to public health and so forth. So that was one of the 3, and so that there were 3, and the other one was like where a railroad needed property, where the government was building a road and it was absolutely necessary, and so forth. So that's the public use, and be mindful that there's a difference between the federal rule and the state rule. And the second requirement in the Constitution, though, is just compensation. Just compensation is the trade-off for the government being entitled to take the property and having the power to do so, even where it's involuntary to the property owner. The property owner is entitled to just compensation. What's just compensation? It's essentially fair market value. And essentially, fair market value is a standard that is used in appraising property for all types of purposes. And essentially, it means where the property is being considered sale and purchase by both parties being knowledgeable and not being compelled time-wise to sell or to buy, and having the property be on the market for a reasonable period of time to determine its where the balance was met between what somebody was willing to sell for and what somebody's willing to buy for, and where those lines meet is a fair market value under those circumstances. And that is really what a property owner is entitled to in just compensation. Now, obviously, there are a lot of sub rules on what compensation is payable for, such as where the government is taking a going business. Is somebody entitled to compensation for their going business? Are they entitled to moving expenses? Those there are all separate rules, and it gets down pretty deep into the weeds. So, in general terms, how is the power of eminent domain exercised on a day-to-day basis by the government, federal, state, local? It usually starts with the government getting some type of appraisal of the property and making what is known as a good faith offer to the property owner. So the government can't just make an arbitrary lowball offer in order to trigger this entitlement to use this awesome power of involuntary taking the property. They've got to make a good faith offer to purchase the property. And if that is rejected, then the government can file a lawsuit asking the court to do two things. The first part of the lawsuit is to transfer the property ownership to the government. And whether that's the possessory interest, an easement, or whatever. So that's what the court is being asked to do, is transfer that property to the government. And then the second thing the government asks for in their complaint is to determine the amount of just compensation that will be paid to the property owner. Now, just very quickly, in terms of practicality, in many instances, if the government is building a road or freeway or whatever, the government may need the property more quickly than it would take to finish a whole trial. And so the legislature in Michigan and most places has passed what is known as a quick take statute, where the government in many instances can gain the right to own the property on an expedited basis, pay what the government has determined to be fair market value into escrow with the court, and then they can fight about just compensation by a jury or whatever, and at the end of that, that's when the property owner will get paid. Another subject comes up frequently, and that's partial takings, often with road widening. And if you take this little diagram, you take the two horizontal lines at the bottom, and let's call those lines, the space between those lines, an existing road. And then the crosshatched segment above that would be where the widening is to occur. And if we say that the private property is the blue rectangle, and within that rectangle is another rectangle, and we'll say that's a home. And so the home starts out in the middle of the property, meeting all the setback requirements and all that. And the widening comes along, and it's going to result in the property or the road being, say, 5 feet, 7 feet from the edge of the road. And So that changes the whole dynamic. The government's only taking a small segment, a portion of the property, but is significantly impacting the balance of the property. So under these circumstances, generally speaking, the government must pay the property owner based upon two criteria. Number one, the value, the fair market value of the property actually taken, that little strip, the crosshatch strip, what's the value of that? And then second, what damage is done to the remainder of the property that's left after the widening and construction of the road. So assuming that will reduce the value of what is left, the property owner is entitled to that as well. Now, it may be in some situations that the property no longer meets the setback requirement. Under Michigan law, the condemning authority is entitled to go to the local government and ask for a variance on behalf of the property owner to make everything lawful. But recognize that in some instances, let's say a variance isn't granted, or there are other problems that are created as a result of the widening, the damage to the remainder may be a total taking of the property. So the government may end up owning the entire piece of property, even though it owns only the little strip at the bottom. So that's really the situation that occurs for partial takings. So let's turn over now to regulatory takings. This is such a complex subject. I can't even hope or pray to get this subject completely communicated. It's very complex, but again, it arises where the government intends only to regulate property, and the property owner ends up initiating a lawsuit claiming that the government's action is so burdensome that it amounts to a taking of the land as if it was eminent domain. Now, the Supreme Court has categorized these takings into three different areas of law, and I'll just go through them, each one of them quickly. Number one would be known as a categorical taking of property. And categorical means that this is going to be considered by the court to be a taking, regardless of other circumstances. One of the major categories here is if the government's action results in a taking of 100% of the value of the property, and not 90% or 95%, because that would come under item number 2 here for consideration. But categorical taking requires 100% of the value being taken. Another area of categorical taking that the court has identified would be where the government's action results in a physical occupation of the property. So, for example, let's assume that the government puts a drainage situation in and runs drainage facilities across the edge of the property. That would mean that the government is occupying the property physically. Now, that would be a permanent physical occupation, and I think the law is not so clear that it requires a permanent physical occupation. It might a lengthy temporary physical occupation may be enough, but where there's a permanent physical occupation, that is considered to be a categorical taking as well. Even though there is a lot of value left in the property, and other circumstances it would indicate otherwise, it's still going to be a taking. And the case where this arose initially was where the government allowed cable television companies to come along and install a cable along apartment buildings. And even though a cable might be virtually invisible, the court said that's a physical occupation and requires just compensation, and because it's a categorical taking. Okay, so let's say that we don't meet the criteria for categorical taking, but the government's regulation may obviously have a significant impact, and so we've got to determine whether or not it will be considered a regulatory taking. In other words, in the words of the court, whether the regulation has gone too far and must be treated as a taking. And for these purposes, the court has created what is fondly known as the balancing of interests tests, or the balancing test. And the government, the balancing test takes into consideration three variables. The intent of the government in doing it, is it good faith or is it bad faith? How much of the value of the property has been taken, and so forth. And the government factors all these things and puts it into a pot, a witch's pot, and stirs it around and determines, yes, it's a taking or not a taking. And I can tell you that that if the case gets into the balancing of interests test, the government has the upper hand, because if there is any substantial value left in the property, and the government is taking it on good faith, then it's not going to be considered to be a taking. The third variable really is beyond explanation. In all 6 sessions of this program, if I took all 6 sessions and talked about the third variable, I'd still not do an adequate job. So I'm not going to go into it in any great detail. The third category of case that arises in determining whether the government's regulation is a taking is where the government is attempting to abate a common law nuisance. Now, bear in mind that a nuisance can arise under common law. In other words, what is a common law nuisance? And you consider all the factors that go into that question. Or the second area where a nuisance may arise would be a statutory or ordinance violation nuisance, where the statute takes a vision. For example, the Zoning Enabling Act specifies that where a property owner fails to comply with a zoning ordinance, that is going to be considered to be a nuisance per se. So a nuisance as a matter of law. The court has held that where the regulation attempts to abate a common law nuisance, that will never be a taking. That will never be a taking. And the reason for that is that if the property owner is taking actions that amount to a common law nuisance that are being prevented by the regulation, the property owner never had the right to do the common law nuisance in the first place, because common law nuisances are not permitted to exist. So there's no basis for saying that that's a taking, because the government really isn't taking anything away that the property owner had in the first place. On the other hand, the court has held that the government may not describe a factual situation that amounts to a nuisance as a matter of law that can be taken away by a statute. Why is that? Or taken away by eminent or by a regulation? Why would that be? That would really open the door to abuse by the government, because the government could merely, if they wanted to take a park, they could define a circumstance that existed with regard to that property and say, okay, we're going to take the park and prohibit anything to be done on that property other than recreation or something to that effect, and completely undermine the property owner's right to just compensation. And so Common law nuisance, no taking. Government defined nuisance as a matter of law, that can still be a taking if it meets either the categorical test or the balancing test. Okay. All right, let's go to part 2 of the program in the session. This is the practical segment, and lawyers probably are going to have some great questions to ask me if I step out of line here, and hopefully this is going to be educational, particularly to people that aren't as familiar with the court system and with the local government attorney. So concepts in terms of the court system, we have an adversary system in the United States, and essentially the adversary system arises out of the philosophy that the truth is most likely to come out if both sides have an opportunity to explain their position to the finder of fact and the finder of law, and give them all the pluses and minuses, and the ultimate finder of fact, the ultimate neutral, will have the benefit of both the position of both sides, and be able to make a decision, rather than any other system where you merely have some arbitrator or whatever come in and look at the facts and make a decision. Now, arbitration that's conducted with 2 adversaries is still part of the adversary system, and is merely just a trial conducted in a different forum. And just to use an analogy here, the adversary system is really analogous to the First Amendment free speech clause. So we have basically decided in this country under the First Amendment that truth is most likely to be divined by both sides, or all sides having an opportunity to weigh in the so-called marketplace of ideas. And then the person that is trying to make up their mind about a subject will hear all sides and have the ability to decide what is the truth, what's right, what's wrong, and so forth. And so the system is somewhat analogous to that. So that's the plaintiff is the party that initiates the lawsuit. The defendant comes in and defends the lawsuit. They both have an opportunity to argue, and I'll touch on that in a moment. And then the other participant in the adversary system is the neutral, and you have a trial judge in that situation, and a trial judge can be certainly the finder of law and the determiner of law in the case, but may also be the finder of fact, in fact and law, and that's where a jury has not been requested, or plaintiff's not entitled to a jury. And in the case of a jury, the jury is the finder of fact, and the judge remains the determiner of law. Okay, let's go to number 2 here. 2 more concepts: law and equity. And so you have a case at law or a case in equity. And what does that mean? So you have these 2 branches of our court system, and historically, you actually had 2 separate courts, one court of law and one court of equity, and only equitable cases could be brought in the court of equity, and only law cases brought in the court of law. Under the 1963 Constitution in Michigan, the Constitution says there shall be one civil action, and it can include both law and equity, and they can be combined in the same case. And so your typical case at law would be a contract case, or maybe a tort case, like a negligence case. They would be cases at law, and in cases that are brought at law, the plaintiff, in some cases maybe the defendant, is entitled to a jury to make findings of fact. On the other hand, the classic case in equity would be your injunction, where the plaintiff is seeking to stop the defendant from doing something that the plaintiff considers to be contrary to the statute or contrary to fairness. The plaintiff brings the case, and that's considered to be an equitable action. And historically, in equity, the judge is both the finder of fact and the finder of law. Although in some cases there's both law and equity, and so the court might bring in a jury to make the findings of fact on the law side, and the court would consider the equity parts. Okay, now rules and officials. You have special rules for the court, and these would be court rules, oddly enough, and so these rules are in Michigan enacted by the Michigan Supreme Court, and they are rules that govern all phases of litigation and actions in court, and the court rules, as interpreted by the court, guide the several steps in the court process. Now, in some cases, the legislature may pass rules that apply to court actions, and so you may have rules from the court rules, and you may have statutory rules. And the general principle is that where a court rule and a statutory rule conflict, the court rule takes precedent. So the Michigan Supreme Court has the ultimate hammer, so to speak, on the rules that apply in the court. And very quickly, the court clerk, that's a person that is the keeper of paper. So when you file a case with the court clerk, and when you make subsequent filings in the case, the clerk is the one that sends things out and sends notices out in many cases. Now today, of course, we're moving rapidly toward a total electronic system. So when you file your what is otherwise your paper, you file it electronically, and the court keeps manages the electronic material, and that is in lieu of the paper. And the court clerk also assigns the judge that might get have jurisdiction over cases. Like Oakland County, there are a whole slew of judges that sit in the circuit court, and the court clerk takes a pad of paper and blindly draws the next name that comes up. They probably do it in a different way today electronically, and whatever that name is the judge that's assigned to the case. And so why do we do it that way? And that's to avoid the situation where somebody can come in and say, I'd like this judge because I know he's a judge that likes me, and or is favorable in negligence cases and likes big verdicts or whatever, and so I'm going to take that judge. Well, judges are assigned on a blind draw basis. You have an assignment clerk, and that clerk schedules cases for pretrials and trials, and in many instances for mediation, which we haven't talked about yet. Two more classifications of cases would be, in addition to your law case and equity case, you have a civil case, a civil action, and a criminal case. So what's the difference there? It's really the subject matter and the parties. In the civil action, you've got, as I mentioned, the plaintiff has a complaint against the defendant. Defendant defends the case, so you've got two private parties that are involved, although the government can be a plaintiff in a civil action where the subject matter is seeking a civil remedy. Whereas a criminal case, it's the government that is the plaintiff. And the government is bringing a case against a defendant, alleging that defendant engaged in criminal activity and should be punished. And one of the principal differences between the cases, aside from those parties, and the remedies involved would be the burden of proof. So in a civil action, the general burden of proof is that the plaintiff must prove their case by the preponderance of evidence, and that means, generally speaking, that the one party has proved the case that it's more likely than not to be correct. So that can be the plaintiff's case is more likely than not correct, or the defendant's case is more likely than not correct. Whereas in a criminal case where you're going to hold a criminal defendant liable, the case has to be demonstrated or proven beyond a reasonable doubt, a really tough standard. So if there's any reasonable doubt, then the prosecutor loses the case. And that, that's a really, thumbnail sketch of those two branches of a court action. The initiation progress of a lawsuit, the complaint is filed. This would be a civil action consisting of a series of predominantly factual statements by the plaintiff, and that all together informs the defendant of the kind of case that is being brought and what kind of facts are alleged that the defendant is responsible for, and that a certain remedy ought to be granted. Then the answer to the complaint is filed, which consists of a series of statements, paragraph by paragraph, responding to the complaint, informing the court and the plaintiff why the defendant doesn't believe that there's been any wrongdoing and why no remedy should be afforded. And now this is a little bit of a simplification, but that's, these are really, this is the structural members or foundation of a civil action. So during the course of a case, the parties may want to talk to the court and ask for some relief of some sort or other, aside from the ultimate trial. And that is done by one party or the other filing what is known as a motion. We're going to file a motion asking the court to decide certain parts of the case before trial, or in some cases, the entire case before trial. And that way, the moving party, the party that's bringing the motion, can come in and tell the court why they want certain relief. The other side can come in and tell the court why they're not entitled to that relief. And so the parties are essentially communicating to the court in the middle of the case. Similarly, the court from time to time, generally at the court's own initiative, will set pretrials, sometimes at the request of the parties, where the parties can come in and either in the courtroom or in the court's chambers can talk to the court about something of interest. Another step in the process of a case will be something known as discovery. And discovery means that each side is trying to discover what the actual case, the complete case of the other side. And that discovery might be undertaken by one side asking some formal written questions to the other side that the other side answers, that gives more information to the party conducting that discovery. Another very popular vehicle for discovery would be the deposition, where one party notices the deposition of a witness, and that witness can be a fact witness or could be an expert witness. And they ask that witness to come in, sit down, be sworn under oath to speak the truth, and then have the opportunity to ask questions of that witness, and thereby, again, becoming more informed of the case, so that when the parties get to trial, they know a great deal about the case of the other side and the defense of the other side, and that promotes settlement, because once more information is garnered about the case, the parties can make a better approximation about how the case may come out, and govern their recommendation to their clients accordingly. a motion for summary relief, as I mentioned before under motion, one party may ask for relief without a trial. That's the summary relief. In Michigan, it might be called Michigan summary disposition. In federal court, it might be called summary judgment or motion to dismiss or something of that effect. And if the court might grant an entire summary relief, might grant partial summary relief, it might deny the whole thing, which would then lead the case to another day for more motions or for trial. Very popular, almost invariably used in cases today would be non-binding mediation, sometimes called facilitation. And this is where one party and some maybe a panel of parties, a panel of individuals comes in, serves as a mediator or a facilitator, hears the arguments of both sides and makes a recommendation on how the case should be settled. And so the main benefit of that, of course, is that it frees up the court's docket from having to go through the whole trial before getting to that point of settlement, or even the pretrial. The court wants to take these cases off its docket and help the parties come to a resolution as soon as possible. And so this mediation and facilitation is intended to achieve that ultimate end. Again, the plaintiff in a lawsuit has the burden of proof, makes an opening statement at a trial, then calls witnesses to testify. Then the other side makes an opening statement, essentially explaining what the case is about, calls witnesses. And because the plaintiff has the burden of proof, whether it is the beyond a reasonable doubt or preponderance, the plaintiff is given the right to then rebut anything that the defendant has presented. And then each party makes a closing argument. Again, the plaintiff has the right to rebut what the defendant says. And then the case goes to the jury or goes to the judge if the judge is serving as the finder of fact. And the fact finder will make a determination, and the court will enter judgment in accordance with the facts that are found. Again, the case goes to the jury in a jury trial, otherwise to the judge. And once the trial is over and a judgment is entered in Michigan, each party is entitled to the right of appeal to the Court of Appeals. And that Court of Appeals is known as the Intermediate Appellate Branch. Each party can take their case there, and the Court of Appeals is considered to be both a policy-making court and an error-correcting court. So if there's been a grievous error made during the trial, the Court of Appeals can correct that error, make a reversal, send the case back, or just decide the case. And then that appeal would be over. And the high court, the Supreme Court in Michigan, only takes cases that it desires to take. So you file an application for leave to appeal, and the court reviews your application and may or may not take the case. And by far, the court only takes a small fraction of cases in which an application has been filed. And the Supreme Court is generally considered or not considered to be an error correcting case court, like the Court of Appeals is. And the Supreme Court is primarily intended to create policy and rules that will apply to subsequent cases and straighten out rules so that parties don't have to bring a case at all because they know what the rule and the outcome is going to be, or they will be bringing their case under a certain policy or rule of law. Okay, let's spring forward to the government attorney, and I'm going to run through this so that we have time for questions. And a local government attorney can be a city attorney, township attorney, village attorney, or county attorney. It can be a road commission attorney. It can, be a drain office attorney, and or whatever, whoever is representing the government and or a government agency. And these attorneys can be either in-house attorneys, which would mean that they're full-time attorneys for that city, township, etc., or for the agency, or they can be contracted, like they can be from a law firm or sole practitioner and be hired on a case-by-case basis or project-by-project basis by the government to handle the cases. Generally speaking, you'll find that larger local governments have in-house attorneys. Like this city of Detroit has a whole battery of in-house attorneys. The city of Troy in Oakland County has in-house counsel, and many of the other communities have contracted attorneys. Now, a local government attorney plays multiple roles. It isn't just a one thing or other, particularly if they're regular in-house attorneys or contracted attorneys that are involved all the time. Examples of the roles played would be first to attend meetings, attend public meetings, and that could be the meetings of the legislative body, like the city council or township board, etc., the board of road commissioners, etc., or it could be at the zoning board of appeals. It could be at the planning commission, and the local government attorney appears at those meetings. In some cases, the attorney appears like they're really doing nothing, but believe me, they're fully engaged because they've got to keep one ear attuned to what is going on to make sure that you don't have a violation of the Open Meetings Act or Freedom of Information Act, or that confidential information is not being violated, and so forth. So there are many services or Robert's Rules of Order, many services the local government attorney is performing, even though they're sitting at a meeting. They look like they're being quiet and not engaged. And the local government attorney also performs significant transactional work. And by transactional, I mean work that does not involve going to court. Many just a matter of a regular diet. The city, county, etc. attorney is assigned to write contracts for the local government, write ordinances or give advice on contracts and ordinances, maybe interpreting contracts and ordinances, preparing resolutions or interpreting them, and providing legal opinions that I'm going to talk about a little bit further, and then keeping the local government up to date on new law, the status of litigation that's pending, and all things like that. So the local government attorney performs a whole multitude of functions. And I think it's interesting to think about anatomy of a legal opinion, because attorneys write these legal opinions, and people that are unfamiliar with this don't understand there's significant actions taken behind the scenes in preparing a legal opinion. First of all, the attorney has to really ascertain, let's assume it's an opinion. If there's an opinion, it's probably at least two stakeholders involved, maybe more. And there's some kind of probable dispute of some sort. The local government can go one way or another. And so in writing an opinion, one of the first things that has to happen is that the attorney has to find out what the provable facts are. What are the facts that are going to drive the outcome of this opinion? And, provable can be subjective in some cases, hopefully as objective as possible. And then the attorney's got to interpret applicable law or governing law. It might be a statute, might be an ordinance, might be case law. And so the government or the attorney's got to do legal research and find out which statute, which case applies. And again, determining the meaning or governance of a statute or case is going to require an interpretation in many cases. So the attorney's got to find out what the facts are, and then find out what law is applicable, and then interpret that law. Okay, so you could go in a lot of different directions. that is often complicated. If the attorney might say, now let's see, now if I decide this way, give an opinion this way, and it goes to court, what's the likely outcome? Or if I decide this way, what's the likely outcome? And the attorney may need to draw on who the judges are that might decide this, because judges make various decisions depending on who the judge is. So that's, again, a very subjective thing. And like in a county like Oakland, there are many judges. And so, and Oakland, Wayne, and so forth, many judges. And so you don't know who the judge is going to be, and you have to, make your best guess. Sometimes there's a legal opinion where a case is already filed and gives the attorney a little bit more guidance there. Then there's, the appellate court. How's the appeals court? So the attorney has to understand the law that has been decided in the appellate courts on a subject in order to do a good legal opinion. And then the attorney has got to write an understandable opinion, and that's not always easy. So these are some of the things that go into writing an opinion. And so attorneys need to be given some credit here, that the unsung heroes, attorneys in preparing legal opinions. And if the opinion turns out to be overturned by the court, somebody might say, well, what's wrong with that attorney? He or she doesn't know what they're doing, and so forth. But the truth is that there's so many variables, and often the law is unclear. So as they say along the highway where there is construction going on, give them a break. Now, I think this is the final slide I have here, leaving time for questions. Questions that may arise in dealing with a local government attorney. These are just 4 or 5 questions that we can quickly discuss. So who should ask the attorney for an opinion? Should anybody in the local government? Should any citizen be able to ask for an opinion? Obviously, that's a dangerous thing. Runs up the clock and legal fees and so forth. And it's like opening the door to problems. And so the local government should have a policy that establishes who in the local government itself, and generally speaking, not the public at large, who should be able to ask the attorney for an opinion. Should the attorney consider politics in representing the local government? Like politics is no, the attorney is not the person in the overall chart of what they're assigned to do, make policy decisions. Normally, the policy decision is made by the legislative body. The legislative body is basically elected. So if the attorney is making that decision, it undermines the election process, because it really should be the elected officials that make policy decisions. Now, obviously, in some cases, like a planning commission might make a policy decision, but that is the way that the statutory system is set up. But generally speaking, policy decisions are made by the legislative body, and certainly not by the attorney. Okay, questions in the chat room, Jim?
Yeah, we do great job, Jerry. Thank you. We have one. It's not a question, really. It's a clarification or request for clarification. It says, I would clarify that where a statute and a court rule conflict, the conflict will be determined in favor of the statute if the statute is an enactment of substantive law, unless the statute applies on to practice and procedures. The statute will prevail over the court's constitutional rulemaking authority. It cites McDougall versus Shands in 1999. Okay,
great. I really appreciate that refinement. I was speaking in more generalities about rules of procedure in the court, and so the legislature, and again, there's a legislative body determining policy, and so substantive policy is in the bailiwick of the legislature, not the court, and so that kind of rule should be made by the legislature. Thank you very much for that clarification.
Okay. And I don't see any other questions in there, and we are past 1 o'clock. So just want to thank you again, Jerry, for today's presentation, as well as just an excellent job on all 6 sessions.
Thank you so
Ryan?
much. It's been my great pleasure, and I really appreciate everybody that has attended these now and maybe in the future. Thank you so much.
Yeah, and I want to echo Jim's sentiments. Thank you, Jerry. Appreciate it. And thank you everyone for joining us today.